The controversy with attorney fees stem from, well, their inherent volatility. You can take two cases with identical fact patterns and the cost of one can be a lot higher than the other. And sometimes that's because one or both parties won't settle, or maybe the client hired some high-priced lawyer for what was really kind of a lower cost dispute, or maybe it's just a little bit of both. Now, most lawyers don't want to sue their clients for unpaid fees because it often invites an ARDC complaint or a cross-claim for legal malpractice. But a desperate lawyer can be just as cutthroat, if not more so, than a client, and some, at least in my opinion, have turned billing into its own cottage industry. Now today I'm going to cover case law that governs what we can and can't charge for, and how I like to set up my chessboard, if you will, when I'm defending a fee petition. But before we go down that rabbit hole, let's recap what this rule actually means.
In Illinois, a lawyer is required to charge a reasonable fee, but for most clients, knowing when a bill is excessive as opposed to merely expensive can be difficult. Generally, the burden of proof is on the attorney to establish the value of their services. Furthermore, they must present more than a mere compilation of hours multiplied by a fixed hourly rate. Rather, they must provide detailed time records that specify the services performed, by whom they were performed, the time expended thereon, and the hourly rate charged. At hearing, the trial court should consider the skill and standing of the attorney, the nature of the case, the difficulty of the issues involved, the importance of the matter, the degree of responsibility required, the customary charges for similar work, the benefit to the client, and whether there is a reasonable connection between the fees requested and the amount involved in the litigation. The court may also rely on their own experience in determining reasonableness, and if a judge awards less than the amount requested, the ruling should include the reasons justifying the reduction.
I have strong opinions when it comes to attorney fee reform. It's an area I feel needs a lot more oversight. But until that happens, this commentary on defending fee petitions is focused on the law as it is, not as it could be. When I first started practicing back in 2008, many of my initial clients were dads facing contempt matters because attorney fees are recoverable in contempt proceedings. So that also meant I had to deal with the inevitable fee petition from the other side. In doing those, I noticed that most lawyers bill within the kind of a reasonable bandwidth, but there were a few firms that often sort of pushed the envelope, or maybe less politely stated, they were demanding tens of thousands of dollars for really nothing burger cases. And they did so because case law holds 508B fees are mandatory. The judge must award something. The only bar is reasonableness. And even in non-family litigation, case law holds that reimbursement of attorney fees in contempt matters is customary. So worst case, if a firm got caught, keyword caught, padding the bill on a contempt charge, the worst that a judge could do was, well, just reduce the award. So a lot of firms will try, even to this day, to sort of sneak things through, especially if the other side is pro se, because most pro se people, they don't know what to point out in the bill as excessive, and more often than not, that's that. Or similar to this, let's say a client is being sued by their former lawyer for unpaid fees. The bill is, well, outrageous. And in either scenario, how do you stop that? Well, here's what I do. Your mileage may vary. I read the bill. 90% of the problems are going to be found right there because over the years, courts have laid down a variety of no-go zones on what we can and shouldn't charge for. The seminal case on this has always been the Kaiser case. Now, Kaiser is a landlord-tenant case, but the Kaiser standard is almost always used in just about every fee petition defense. It lists out all sorts of things you should not bill for, such as charging legal fees for work that a pet rock can do, like mailing a letter, or other costs such as Lexis, Westlaw, or Fastcase. Actually, Fastcase comes free with an ISBN membership, but be that as it may, those costs are built into your hourly rate and shouldn't be charged separately. Another example in Kaiser is routine photocopying costs or postage or the like. And in addition, Kaiser mandates that the billing description identify what's going on. And logging in 1 hour for just research without noting what it's for can be a problem, especially let's say it's an uncontested divorce where anyone with a law license should be able to do it with both hands tied behind their back. Knock on wood. But Kaiser isn't the only case I look at. Case law has touched on other unique charges like transportation. Here's a case involving taxi fare, which in today's world I guess would be Uber, and in it the fees were disallowed. Similar to that, travel fees. Travel fees generally shouldn't be incurred against the client, or at least shouldn't, unless there's a very good reason the client couldn't get local counsel. Likely this would be more applicable in counties with a population of, let's say, cow and tire. But on the flip side, there are other fees that are allowable, and the most controversial in my mind, which I covered in this video, which was clearly before I started hitting the gym, were enhancement fees, namely an additional fee to be negotiated if the firm brought value to the case, whatever that means. And be that as it may, enhancement fees are allowed provided they were not already subsumed into the hourly rate, which means the court has to look at the contract to see if the fee is an enhancement or merely a clever means of double billing. As an interesting aside, there's actually case law that allows a judge to limit how much you can collect from your client if the court felt you failed to control them. Now, this is in the context of a civil case. I don't really imagine a judge is going to ding a criminal defense attorney because their client did something while on bond. And the case in question is Oriema. It's a divorce case. The matter on appeal was contribution. That's where the law firm is seeking an allocation of fees, not only from their client, but also the other side. They wanted $150,000, but the trial court awarded only a fraction, not just against the other side, but also what they could collect from their own client. The appellate court upheld this reduction of fees because they agreed the law firm failed to control the litigiousness of their own client. Now, the facts in that case were they were pretty extreme. The husband wiretapped his ex's phone. Litigation was spilling through multiple counties, you name it, but it serves as a reminder that as attorneys, we need to watch where our cases go. So to recap, I start with the bill and I zero in on the costs. And once I walk those out, I then turn to what they actually bill for, or as I like to call it, the smell test. For example, a 30-minute hearing where no testimony or discovery was done probably shouldn't cost $10,000. Thankfully, one thing I have found to be true in attorney fee defenses is that judges, no matter how much they dislike your client, well, they hate bill padding a lot more. And I think, and your mileage may vary on this, it's because they find it insulting. Most of these judges, they've been on the bench for a while. There's nothing they haven't seen. And prior to that, majority were in private practice themselves. As a matter of fact, this experience is fair game when valuing services. So to come up before a judge with a straight face and tell them that an uncontested divorce was worth almost $6,000, don't be shocked if they shove a donut down your throat, which is what happened in this Rule 23 case, and the appellate court upheld the donut because the lawyer wanted an additional $3,000 for an uncontested divorce, and this is after they were already paid $2,500. And keep in mind, there was nothing special about that case. It was a rubber stamp uncontested divorce from start to finish. I myself defend a similar case. Dad hires Per Your Law out of Iowa for his divorce in Rock Island. It appears the only thing Per Your did, as far as I could tell, was kind of send him monthly bills. And after a while, Dad says, hey, I think these fees are a bit excessive. The firm sues him and his mom because she co-signed on the agreement for about twice of what they owed. Now, I'll get to how firms pull this trick at the end of the broadcast and what you can do about it. But the point is, the judge gave them a donut. They appealed. We had to go and do oral arguments. And in a Rule 23 order, which can't be cited because it was published a month before the rule change, the appellate court upheld the donut, and the client and the family were saved from what was clearly a crippling judgment. So yes, Virginia, a trial judge can award a donut if the law firm gets too greedy in their billing. But the key to arguing that is the smell test, i.e., were those fees consistent with similar cases? Because of all those earlier factors I cited at the beginning of the broadcast, the most important one, the one that zeroed in the most, is the time billed and why it was necessary to bill that time. As a lawyer, if you can't justify why it took you that long to do what you did, you're probably fighting an uphill battle, which leads us right into our main event. In our main event, a father gets hit with a fee petition by his former law firm. He had hired them to terminate his alimony, which in Illinois we call maintenance. Well, it gets terminated. Now they want over $100,000 in unpaid fees for their troubles, and this is on top of however much Dad already paid them to initiate the case. Dad says, hey, these fees are outrageous, especially since they bill in 15-minute increments. Now, I have nothing against the law firm in this case. I'm not looking to start a beef, but I'm also not a huge fan of billing once you get into that 15-minute increment block. Now, to be fair, most lawyers use minimum blocks. Otherwise, everything we do is going to need a stopwatch. Like, hey, was this email 1 minute and 59 seconds, or was it 2 minutes? You know, do we round up or do we round down, etc.? And 5-minute blocks is what I use. Others use 10. But once you get to 15, like the firm here does, it can lead to, well, it could lead to overbilling. And here's what I mean. Let's take this notice of filing. Big shocker, we template most of your routine filings. So I just sent a 201k letter. I'm going to file a notice of filing indicating I just did this. And yes, I'm one of those lawyers that logs 201ks. Anyways, I just used this notice of filing earlier in the week to attach to a response in that case. So I'm just going to do this and this. That took about 45 seconds. But the firm charging in 15-minute blocks is going to, you guessed it, log 15 minutes. Usually the paralegal drafts that, so you're probably going to be charged the paralegal rate. Then the attorney assigned to it reviews it for accuracy, which is kind of like having the weatherman walk outside to see if there's still fresh air to breathe, whatever. So that's another 15 minutes. Then I'm going to go on to this website and e-file, and that takes about 2 minutes, maybe 3. The interface can be a little slow on some days, but anyways, the firm charges 15 minutes to do this, hopefully at a paralegal fee. So you got a filing that they charge 30 minutes of paralegal time, which might be $175 per hour or $87.50. And then you got 15 minutes of billable time at the attorney rate at $350 per hour for a 4 or 5 minute job, which also comes out to $87.50. Now compare this with firms that bill in 10-minute increments, and now if they did the same thing in 5-minute increments. And finally, compare that to solos and small firms who do it themselves because a pet rock can handle a freaking notice of filing. So even though it's $350 per hour, if you bill in 15-minute increments, certain real-world work, if you extrapolate that 5 minutes of actual work into an hour, puts you at a true billing rate of $2,100 per hour. Wow. Here's another way, and similar to what the firm did in today's case, they set a floor on routine stuff. For example, any court filing, 1 hour minimum. So that notice of filing that cost my clients maybe $29, well, they charge $350. No, actually, the opinion indicates they raised their rates to $400 per hour, so it was actually $400. And that 5-minute Zoom status call, especially in DuPage when the courtrooms run like clockwork, that too was automatically charged at an hour. And from my perspective, that's how some firms mask raises to their hourly rates without raising their hourly rates. They bill in larger time increments or make you pay the full hour for 5 minutes of actual work. Now, before anyone fires off an angry email to their attorney accusing them of churning fees, keep in mind, the associates in a lot of these firms, they're under tremendous pressure. Most have minimum billing requirements. 40 hours is often the industry standard. If they can't find 40 hours per week to bill, the partner will find an associate who can, and lawyers get let go from firms like these all the time. So did Dad win his argument? Well, the trial court knocks off about 30 hours of what they felt were unreasonable blocks of time, or about $12,000. But upholds the rest. Dad appeals, and the appellate court reluctantly upholds the 15-minute billing blocks in this case, but for a few unique reasons. First, Dad apparently kind of stood mute for months and months while the bills were kind of rolling in. It didn't say anything. It wasn't until he was sued that he started complaining. Second, the firm didn't bill for every email. And third, the firm did get Dad what he wanted, a termination of maintenance, and results are a factor the court can consider when weighing the fee award. So the award stands, but, and there's always a but, the cautionary dicta of the opinion strongly suggests 15 minutes is the max tolerance because of the overbilling possibilities. We're almost done. I know it's been kind of a long video, but I did promise I'd come back and show how firms double charge in different areas, and that's by writing contracts that require you to pay for their collection costs or interest. Usually it's around 6 or 9%, for any unpaid amount, or make you pay for their attorneys if they hire a firm to sue you, and so forth. So that $1,000 in unpaid fees sometimes ends up being around $2,000 by the time they sue. Something to be mindful of before you sign that contract. So let's recap how I set up my chessboard for defending a fee petition. First, I walk out the disallowed costs. Second, I do the smell test. Based on my experience as a family law attorney, do these costs for this type of work make sense? I.e., are they charging $6,000 for an uncontested divorce? Third, if it smells, I then review the bill to see if they're, overbilling or overcharging, such as charging massive time for legal research on routine matters that we always have to deal with as practitioners. And then finally, I look at their minimum billing increments. There's one firm in Chicago that caters to the rights of a particular gender, if you will, in family cases. They bill in 15-minute blocks, if you can believe that. Anyways, I will look at that as well. And if we're hitting bullseyes on every box, odds are it's probably an excessive bill and one you may wish to challenge. In closing, I'm sure you can see there's lots that goes into a fee petition defense. I'm just kind of scratching the surface here, but hopefully there's enough to give you an idea of what to look for and perhaps more importantly, what to avoid. Anyways, that's all I have. Thanks for watching.
Like a rock, I was strong as I could be. Like a rock, nothing ever got to me. Like